We've come to the end of the IFA Copenhagen Congress. 4 days of, I should say 5 days of non-stop action. Beginning Sunday, we had the opening ceremony. Day one, you had a lot of action. We discussed exchange of information. We've discussed BEPS. We've discussed recent developments in international tax. I don't think there's any topic we haven't discussed. And I have an illustrious guest with me, special guest, Philip Baker, Queen's Counsel, one of the most renowned tax professionals in the world, and of course my colleague Ameya from Taxpayer. Philip, your first thoughts, concluding thoughts on this Congress.
It's been a very good Congress. We've ranged across a wide variety of different topics. I think the standard of the presentations has been extremely good. The organisation has been excellent, and in many respects it's an improvement on previous years. So it sets a very high standard for Mumbai next year.
Yeah. On some of the technical topics, Philip, any thoughts on BEPS, on international tax, on what the tax system will look after 25 years?
How the world tax system will look in 25 years. I think by that stage I'll be kicking up daisies, as we say, so I don't have to worry about it. BEPS is clearly dominating the agenda, and it's dominated the discussions here. We dealt with non-BEPS developments in the recent development seminar this morning because we'd already had a whole day given over to BEPS discussions. Now it's the matter of the OECD taking the action plans and starting to implement them, and they've got a very, very, very tight timescale, particularly if they're going to work not just with the OECD countries who have experience of working together, but also bringing in the non-OECD G20 countries like India, who haven't had this experience up till now. So there's going to be a very steep learning curve for people from India, Brazil, Russia, the non-OECD countries, to see how these OECD working parties have worked in the past, how they want them to change for the future. By this time next year, Mumbai will be just after the first deadline. The first deadline for the completion of the first element of the BEPS work is going to be September next year. So, end of October, Mumbai, we will have an opportunity to review how far that work has come, or alternatively, to see whether there are serious barriers in the way of the work being completed. So that's been, if in a sense, the dominant theme of this session.
Amay?
I think Arun, from the conference and the discussions, so two critical points from an India perspective. The first is on the exchange of information. The second day technical topic discussed the international cooperation, exchange of information, especially in the Indian context. I think that's going to play a critical role in the coming few years. I heard that OECD also mentioning that they are going to do several trainings across India for the IRS officers to sensitize them about how to use this effectively. So I think that will be a game changer. And second, I think the classical debate between source-based taxation versus residence-based taxation. I think the source-based taxation, in my view, will dominate the scene in next few years.
Philip, any thoughts on that?
Well,
We interviewed Mr. Amanj a couple of hours ago, and he seemed to suggest that's going to be the next debate once BEPS is settled. That's going to be the hot debate.
we saw some residents. Well, in a sense, it actually is part of the debate. I'm not so certain that there is actually that appetite for change of the balance between source and residence. You can see that residence countries are presently losing out through base erosion activities. They don't, I suspect, intend to combat base erosion only to give away tax to source countries. And don't forget, of course, and this is something that one has to remember when one's looking at BEPS, the income taxes on corporate groups, that's only part of the picture. Consumption tax, of course, is collected in the country where the consumer is acquiring the goods or the services. That's an important factor which, in a sense, underlies the BEPS project. Those countries like the US, like India, that do not have a generalized consumption tax of VAT or GST, they are not tapping part of the tax base, which is linked to their own population. It's linked to consumption there. And I don't think other countries are likely to say, yes, we'll give up our income tax base from our residents in order to compensate you for the fact that you've taken a policy decision or you're just slow on implementing a very obvious international change. And there may well be that there's going to be greater pressure to say, well, yeah, we're not prepared to sort of change the balance with source taxation if you are not already taxing consumption in your country. Let me come back to the earlier point on exchange of information. There's no doubt there has been a worldwide shift this year, the movement of the G8, the G20 to adopt automatic exchange of information. That is a very, very powerful weapon. And the principle has now been established. We have the instruments for supporting it. What now needs to be developed are the internal procedures within revenue authorities to ensure that this information is useful. Because you can exchange a huge amount of information automatically, but if you can't tie it to a taxpayer because you haven't got an electronic identifier for the taxpayer, or because the fields aren't properly worked out in the electronic medium, then it's pointless. So there's a lot of work to be done between revenue authorities on that point. An important issue that comes in here, and this is looking ahead beyond Mumbai to Basel 2015, is the protection of the taxpayer. The exchange of information can cause a great deal of damage.
Right now, that's been steamrolled, Philip. That concern has been steamrolled, and I don't think the countries right now, the G8, the G20, are too bothered about taxpayer rights.
Well, I'm not
privacy
certain,
angles.
I'm not certain that's right, because I don't think it's going to leave the table, and
Courts
they
could
know.
step in. You think this is unconstitutional?
Courts will certainly step in, because if information is exchanged from country A to country B, and country B, the information leaks out, then there will be actions in the courts, either in A or in B, against the revenue authorities, and it will require the authorities to step up their game in terms of confidentiality and the protection of taxpayers. So it's not going to go off the table. It's there for Basel 2015. We're looking at, I'm one of the general reporters, the practical protection of taxpayers' rights. Revenue authorities, if they want more extensive powers, have got to match them by safeguards.
Ameya, one of the interesting points, since we have constraint of time, is transfer pricing. You had Mr. Morris from General Electric make some critical points expressing concerns of the industry on transfer pricing.
Yeah.
Could you just summarize that?
I think the transfer pricing and the arm's length principle continuity is OECD is relooking at that principle. In India, we have number of judgments interpreting these principles, huge litigation and disputes. Safe harbor provisions that have been announced a couple of weeks ago by the government are good in the direction of settling this dispute, but I think much needs to be done on settling the transfer pricing disputes. I think arm's length principle will stay in India for some time as well.
They're calling for formula-based approach. That's what Mr. Morris called for. He said you need a formula-based approach, else transfer pricing will collapse under its own weight. Too much documentation, too much information, but what are the revenue authorities doing with that? How do you simplify transfer pricing documentation? Isn't it a paradox in itself, Mr. Baker?
Well, I'm not quite certain that Will Morris was exactly calling for formulary apportionment there. I think he was saying that
some formulas.
well, arm's length transactional transfer pricing, the traditional transfer pricing, and formula approaches are likely to come closer to one another. And that actually was what I found very interesting in the presentation from TP Oswald today about the draft safe harbor rules in India. It seems to me that with those, you are moving towards the Brazilian type approach of fixed percentages, which, whilst they may be starting a safe harbor, they could become the norm. And any departure from the norm would be, in effect, inviting an investigation and the need to explain why the safe harbor is not being followed. I suspect that one of the interesting comments that came out of the discussion on international tax in 25 years was that arm's length transfer pricing will still be here in name, but it will actually be formula apportionment in reality. Yeah. And let's be clear, arm's length transfer pricing, I don't agree with Will Morris, it doesn't work. At the edges, you cannot agree, and those edges are getting bigger and bigger and more important. There is no realistic way to calculate the arm's length price on a unique intangible that you would never sell outside the business. So you've got to have effectively some sort of formula. If the formula is not the same for every country, then you are almost certain to end up with double taxation or some double non-taxation, only if you can have an agreed formula. Now, that being said, a body like the OECD that is very committed to transactional arm's length transfer pricing, the old form, the guidelines, is in a bit of a quandary. Because they are defending the old ways, while maybe hearing people saying you have got to go towards a commonly accepted formula. That will be an interesting issue. Commenting very briefly on BEPS, BEPS is an attempt to preserve many of the traditional principles of international taxation. There's very little revolutionary or really new forward thinking on BEPS. And in transfer pricing, in effect, any form of formula approach has been pushed off the table, just as I think any attempt to seriously control tax competition between governments has been pushed off the table. Any attempt to try to define what is effective taxation, state sovereignty is still the starting point. And once you say states can compete and there's no real principles on exactly what they can do, then you've got to focus on rules that limit the operation of companies. And that's what they're doing with BEPS. I'm not certain how successful that's going to be.
Two larger themes, Philip. One, I think the point that you touched upon this morning in your session was on the lesser developed countries now having a larger role. Jeffrey Owens mentioned that point. And the second point, the relationship between tax administration and taxpayers. So much of it, Philip, is a result of that trust deficit between taxpayers and tax administrators. Is it possible, that was one of the also the questions for the tax system, how it will look in the next 25 years, is it actually possible for that trust deficit to come down? What will it take to reduce that trust gap?
Okay, let's take those two issues separately. The first issue of the less developed countries, hugely important, because BEPS project extends from the OECD countries to those G20 countries that want to participate, and it seems that most of them want to do so. There is hardly a reference to the rest of the world. Brief reference to the fact that the UN does some work on tax and could have an input pact for the rest of the input on behalf of the rest of the world. I think it's extremely unlikely that less developed countries are going to accept that position, that they don't have a seat at the table other than indirectly through an organization which is itself largely dominated by OECD and G20 representatives. So I think Jeffrey Owens was absolutely right to highlight the importance of the role of less developed countries. You look in your own region, all around India, a number of much smaller, less developed countries that desperately need revenue sources. Is India going to represent the interests of Bhutan, Nepal, Sri Lanka, all of these other countries, let alone mentioning India representing the interests of Pakistan? Be fascinating there. So that's a very important issue, and I think that let's step back from it a second. We have an issue about the correct organization worldwide that should be leading on tax. The OECD leads because of a historical accident. The UN stopped its work on tax in the early 1950s as a result of the Cold War. It happened that a couple of former delegates knew about the OEEC at the time and said, let's see whether that could pick up on tax. And the OECD that grew out of it became the dominant organization. But it's not a democratic representative organization worldwide. The question is whether you go with a small organization that represents a small number of countries, where you, in theory, can get consensus, and something that is much more democratic in the sense of representing the world more broadly, i.e. the UN. I will be very interested to see the first meeting of the new UN committee when it meets in October. Now, that's all been on your first question. Shall I draw breath before I turn to your second
Surely.
question?
Till that, we go to Ameya. Ameya, any thoughts on the second question? There was a lot of discussion on that today. The trust gap between tax administration and taxpayer.
Yes, I think in the Indian context, I think that is one of the biggest issues which is being faced. One on a policy level, and then actually on the ground, a lot of transfer pricing disputes, for example, are emanating from that. And I think both the sides, the taxpayers as well as the tax administrators, need to sort of come together. And I think even the professionals will have to play a critical role in sort of bridging this trust deficit. I think in the Indian context, that is absolutely necessary.
Philip, how do you do that?
I do think that that's not a problem that is common to every country. From my dealings with matters in relation to India, I think it is a problem that you have in India.
But Philip, to be fair, you had a panelist this morning from Europe saying that there can never be a honeymoon between the taxpayers and the tax administrator. I mean, it has been a contentious relationship. It's been a love-hate love at best.
I can tell you that when I was supposed to be on honeymoon, I actually ended up attending a tax conference, which my wife has never forgiven me about, and always reminds me that she and I never had a honeymoon. And my goodness me, that's created a long-term contentious relationship there. No, but you were talking about the trust deficit. I would be inclined to think that if you asked any corporate tax manager in the UK, do you trust the customer relations manager you are dealing with, the answer would unquestionably be yes, of course I do. There is a relationship of trust. It's a partially antagonistic relationship because the two organizations, the company, HMRC, they have different interests, but it can be a cooperative relationship of trust even though there are different interests concerned. No, I think there are certain countries where the training level, the pressures on the revenue officials to come up with results, the fact that people are not, revenue officials can issue assessments without really thinking about the consequences that may have. A lot has to be examined. I thought it was extremely interesting. T.P. Oswald highlighted Dr. Shone's new book on tax administration in India, and he highlighted the fact that there are going to be committees looking at the structure of the Indian tax administration, and clearly from my own limited experience, these issues need to be addressed. And there are lots of precedents around the world that you can look at where relationships have been built up rather better with between tax authorities and their, in inverted commas, we're referred to in the UK as customers. Right. I am a customer of HMRC. The comment that is usually made is that as a customer, I am entitled to change my custom, and I can...
So Baker, just a point, the APA authorities this time
Yeah.
APA authorities this time referred the APA applicants as their clients. I think that's a welcome change that we must mention
and
in
that's
India.
a recurring theme in the book that you just mentioned, written by Dr. Shom.
Yeah.
That's a
Yes.
recurring theme, that you
Yes.
look at it as a customer and therefore deliver the best service. Philip, I want to touch upon a very interesting theme again that was touched upon yesterday in part by one of the panelists: public pressure. Tax was on page 23. It's now on page 1.
Yes.
That's made a difference.
Mm-hmm.
That's made a difference to everyone's lives, including you and me. The question is, how does it affect the way we know how it's affected the policymakers? The result is BEPS. How does it affect the judiciary when they give judgments? Once these issues are on page 1, does it somewhere put a psychological pressure on the judiciary as well, that the public is watching now? You can't shoo away a judgment and think it will be on page 20 in the business section.
I don't know the answer to that because I'm not a judge. I am an advocate, and I think I've always had to take into account in my approach towards litigation the fact that the judge has always had an element of audience, even if it is only the professional audience or the audience of the appeal court. So judges are always aware that their judgments are in the public domain. I'm not certain that the general public concern about tax planning, tax avoidance, I'm not certain that that would influence a judge to a great extent. But ask a judge. Don't ask me.
Perfect. Ameya, closing thoughts?
No, I think these are interesting times. This conference has been excellent. I think Mumbai conference will be even better. So
Absolutely. That's the reason we have this backdrop. IFA 2014 Congress is going to be from Mumbai, Philip, and we hope to see you there. It's going to be a lot of action, and I'm sure. I heard that you want to see Shah Rukh Khan dance, right, Philip?
Well, you know that we've got a little tradition in the recent developments that either we have a song or a dance.
Right.
I actually asked TP whether there is a song about Mumbai, and he said yes, there's a song, but it's in Hindi. And I thought, well, can I get him to sing it at the end? And we thought maybe not actually.
Maybe Philip, we heard you sing this morning.
No way. No way.
You're going to sing in Mumbai.
I'm not doing the recent development seminar. I will be one of the general reporters for the year afterwards. So typically, I would not be on a panel in Mumbai because I will have my commitments tied up because of being a general reporter.
But
So,
we will catch you, Philip, in Mumbai as well. It is going to be an exciting Congress. After 17 years, we should tell all our viewers, after 17 years, the IFA Congress will be back to India. It was Delhi first time in 1997. Philip, were you there at that time?
No, I wasn't actually. I was not as involved in IFA at the time as I am now.
Yeah. So India is one of the largest branches of IFA with around 600 members, and it's among the top 5 branches. Back to Mumbai, back to India after 17 years. We look forward to meeting a lot of you there in person. Thanks so much, Philip. Thanking Ameya as well for joining us. It's been an exciting 5 days here in Copenhagen. Thank you all. Thank you all for seeing our coverage. Thank you.